bit on setup and shtick, as it were. We were trying to go for a Tonight Show type theme with Letterman or Leno or whoever you might prefer at the desk. Then we have the distinguished guest, all good-looking guys, and they're going to interview them. And that was our thing. So we're going to try to stick with that a little bit. I got an email question. Awesome. That was cool. It was about the listed conditions, which they are in the article. 17 of them were approved initially with the Act, which was a back and forth. There were conditions that were initially suggested that were not included in the 17, and then there were others that were added in. And then since the original 17, I think Barack mentioned that other conditions have been added. So, and I think we're going to touch on that a little bit more. Before we start with the substantive next panel, we wanted to give you a little bit of insight on what we did yesterday, which was tour a medical marijuana dispensary. We've been doing this presentation since April 2016 on and off. This is the first time we've done it since the dispensaries were open. So in the past, we were always talking theoretically about, well, there's going to be a dispensary, and it's going to look like something, and you're going to do something, and you're going to get weed. When we're preparing for this, I realized that, hey, we can actually go to a dispensary and ask them how this works. So I did the professional thing. I used my insider information, and I looked on Google, and I found the closest one, and I called them. I told them what we were doing, that we were going to be speaking with some people on Friday, and they said, sure, come on out. So we went out yesterday afternoon, and we spent, maybe an hour and a half there?
We could have spent all day there. It was so fascinating. I think that they reached the limit with us a little bit, so we cut it short out.
Yeah, they were very welcoming. They walked us through the whole facility. And if you guys want to, Barack and Jacqueline, give some input initially, this is the waiting room, so to speak, and it's not something that you can just waltz in and walk around and pick what you want. There's some considerable security parameters. We had to provide them with our IDs, even though we weren't there to buy anything. Give them your IDs, they give you a badge. There's a security officer who sits in the green chair right there. You want to explain? You guys talked to the pharmacist.
Right, so behind that door right there, that's the only door that was not a secure access door. All the other doors in the facility were the bulletproof doors. You needed the passes to get through, very high security. The door right there led to a very small room where the pharmacist was housed. She would talk to people on an as-needed basis. If someone wanted to come in and talk to her, she'd be available. If they didn't want to talk and they wanted to go right into the product room, they were absolutely able to do so. She indicated to us that the people that she spoke to most were people who have never touched marijuana. They have no clue at all, so they really wanted some guidance on what products would work best. What she found the most interesting is that she was taught when she went through the training, which her training, she very was candid in saying, was only a 4-hour program. And she said, during this program, they really taught us nothing. What I'm learning is every day talking to the people. But in that program, they taught her that the best combination is a 1-to-1 ratio between the THC and the CBD. What's so interesting about this is this dispensary, and I think all the dispensaries throughout Pennsylvania, are yet to receive products that are CBD. So right now they have the THC products. So when she's giving recommendations to people, it really is a trial and error type thing, because it's not what they were taught to be the best standard. So she then gives them her opinions, and then they transfer into this room, which is what I call like the fancy juice room, spa room. It was very nice. It was very pretty to look at. And behind those counters were techs. The techs had to go through a 2-hour training. And again, it's a very small amount of training, but they were the people that really knew the nuances of the different products. How much you want to take, how strong the effect is, what the effect is. Is it a product that's going to make someone feel more awake, or is it one that they should be taking at night? And that's really where the patients would decide what they're going to get. So as the doctor indicated, he is not giving a prescription, so to say. He's giving a recommendation on what someone might take. But at the end of the day, it's really that patient's decision what they get and where they get that information from, mostly to what they end up picking is from these individuals, the techs at the facilities.
Yeah, it was, from my perspective, what's the environment? I agree, it was very clean, very comfortable. Maybe a little overstaffed, there was a lot of techs there. It was busy, but they have to kind of filter people to let them in. They don't just let everybody walk into the area that you see here with the where the product is displayed. They usually meet with the pharmacist first, so it's kind of a queue line, so to speak. We got from them some materials that I thought were really interesting. We're not marketing for the Keystone shops of Devon, but this is interesting stuff because I've had a lot of clients ask me about this because insurance carriers, self-insured employers are curious. You know, what's going on with this? Is it an all-cash business? The answer right now, yes. Is it something where they go in and they meet with the doctor and the doctor tells them exactly what they need to have and how long they should use it, that sort of thing? The answer to that is probably maybe. I think it might depend on which dispensary you go to, and I think the doctor touched on that a little bit. We have their patient acknowledgement form that they have all the patients sign, and just some other materials I was going to pass around that you can look at while you're listening to the next panel. Brock, did you have any other?
Yeah, I thought one of the things that was interesting was that there's an obvious application for this medical cannabis for workers' comp, general health insurance, liability issues, all those sorts of things. And the problem you have, of course, is that it's a cash business. And we actually were asking about if they had thought about any sort of alternative mechanisms for payments in case an insurer wanted to pay, if they made that decision. And they have, at least at this particular dispensary, they haven't even started building those solutions yet.
Okay.
Absolutely.
Yes, please.
One of the challenges, if you look at it, has to do with banking regulations. The banks, I can't remember the name of it, you guys probably know better than I do, but several years ago there was legislation put in place that restricted banks from being involved in any type of business like this. And even from the standpoint of anybody who does transactions, including PayPal, any debit cards, you can't use debit cards, you can't use PayPal. If you go out to Nevada or places in other states, they actually have ATM cards, so that when you go into the dispensary, you can put your ATM card in there and you can get your cash, because they are not allowed to even use credit unions at this point in time. So it is a problem, and it's sitting there. And a good friend of mine is on the board actually for the Fed here in Philadelphia, and he said they put legislation out there, or they introduced some discussions, but they still can't get it moved forward. So until something happens in the banking regulation at a federal level, this is going to be a cash business. So it does present a lot of challenges for management.
And that's actually a great segue into what we're going to talk about next. In the next section, we are going to discuss how people get the product. We kind of jumped ahead a little bit to the dispensary, but we'll also talk about why there are these issues with the federal banking and whatnot. So without any further ado, I think we have another little video.
Janitor? Janitor?
Sorry about that. What is a scientist?
Could you, I know this isn't your responsibility, but would you be in here and run this down to the supply department for me? It's on the second floor.
Just run this down?
Yes, but make sure you bring the order right back to me. I need it ASAP.
Gotcha. Hey, I know this isn't your responsibility, but just mop the rest of this shit up. I'll be right back. Don't spill it now. Smell it. Okay, here you go.
That's all you need?
I guess, I don't know.
Just...
Okay. Hey. And if someone's having a party or Somebody gotta do their shirt laundry.
Here you go. 1 pound of marijuana, and you sign it, right?
I signed for this and this one. Take it. Thank you. Thank you very much. Some good shit.
Oh, thank you, thank you. Thank you. Okay, here's a little something for your troubles.
Thank you. Thank you.
Let's not
Hey, why'd you tell me we're into this shit, man? We could have been hanging out months ago.
The Food and Drug Administration are having us do a study to determine what, if any, are the medicinal purposes of marijuana.
Wow. If you ever need a guinea pig, let me know, you know. My grandfather was in the Tuskegee experiments.
Really?
So,
Where'd you get that video?
that's a clip from Half Baked. Surprisingly, it didn't win any Oscars, but perhaps some of you saw it. For those of you who have not seen the movie, or perhaps haven't seen it in the last decade, the janitor in that scene, played by Dave Chappelle, his name is Thurgood. What Thurgood then does, and as the movie goes along, it gets even less appropriate. Thurgood goes home. He smokes the medical grade marijuana with his friends. They absolutely love it. They think it's the best high they've ever had. And so they need to devise a plan on how they're going to get more. So what else do? They decide that they're going to rob the facility and steal the medical marijuana. So that's how Thurgood and his friends decided to get the medical marijuana. But as we know, there are perhaps easier and now much more legal ways to obtain the product without having to be a janitor in a medical facility and without having to convince your friends to rob it with you. So Dr. Nicholson and Brock had discussed a bit of the medical behind it. What we're going to discuss a little bit further is who can get the medical marijuana product, how they go about getting it, and more importantly, what if these individuals are your employees or your potential employees? Here to discuss that, we have Rob Baker and Steve Auerbach. Brock is also going to join, and Jason and the doctor as they see fit. Steve is the founder and principal of the Keystone Cannabis Law. That is a division of the law office of Stephen Auerbach. He maintains both a marijuana and non-marijuana practice. His non-marijuana practice focuses on labor and employment issues. Steve has served as the executive director of the Cannabis Growers Association of Pennsylvania. He currently serves as the Philadelphia chapter president of the Pennsylvania Medical Cannabis Society. He has assisted multiple state senators and representatives in shaping their drug reform policies. He has also proposed amendments, additions, and guidance to Senate Bill 3 and House Bill 1432, which is the Medical Cannabis Act. Rob Baker, he is a partner at Chartwell Law. He focuses his practice in Pennsylvania with a large presence in the Harrisburg region. His practice is focused upon defense of general employment and workers' compensation matters. He routinely represents employers in their labor and employment matters. Interestingly, before joining Chartwell, Rob was corporate director of human resources for a continuing care retirement community, and in that capacity, he was responsible for employment law compliance, employee relations, and workers' compensation management. So Rob has a unique experience of seeing, identifying, and handling employment issues both as an employer and as a litigator. Where we're going to start a bit is kind of picking up where the doctor left off with regard to the conditions. The conditions are listed on the handout. They are listed on pages 1 and 2, and that handout also describes for you the additions that will be made. The list is long, and as we now know, it's going to get a little bit longer. They are doing some things to combine some categories, but no categories are being eliminated at this point. What I think is so fascinating about that, yes?
I don't want to rain on the parade, but I'm on page 2.
Oh, well, we'll make sure you get one. Page 2. Is it all missing at page 2? Oh gosh. Okay, well, we'll reprint that. You have some, okay, so some are, some aren't. We'll make sure that you get the page 2. We're reprinting them now. So you don't necessarily need that for now. It's just a better reference for when you leave and have that. But what's really significant in reviewing those conditions is that they are conditions that affect a tremendous amount of people. For example, cancer is listed, post-traumatic stress disorder. There's also the severe chronic pain that's listed. I'm sure if we polled the room, almost everyone can think of a condition that's listed on there that has affected someone that they are very close to, or perhaps affect you yourselves. So it's obviously going to be, medical marijuana is going to continue to be on the forefront of what treaters are going to look for as a solution for a lot of the conditions that they see on a day-to-day basis. So Steve, I'm going to start with you. Let's say that a doctor diagnosed me with one of these conditions 5 years ago. I continue to suffer. I now want to try medical marijuana. What can I do? Can I just call up a local drug dealer, ask for some pot, and then if the cops arrest me, tell them I'm suffering from a condition?
Well, it depends who the person is. If someone is a minor or is not a minor, assuming for the instance that your one is not a minor, suffers from a pre-existing condition, I would advise strongly against going on the street, though as the doctor said, it will likely be cheaper. The proper protocol, it's listed on the Department of Health website, but just to summarize it, essentially what you would do is you would find a doctor who is registered to dispense medical marijuana. Not dispense it, but to offer recommendations for it. Currently this is a searchable database, but after May 12th, that will be harder to do. That's just to save doctors anonymity. Some doctors have expressed fears that they don't want to be known as a medical marijuana doctor.
And Steve, can doctors advertise that?
So it depends. I've issued advisory opinions on it. I take the position that you should not. So there are questions as to, there's an app called Weed Maps. I think my office is on it. I've gotten calls from all over the country, people who have driven through Pennsylvania and have gotten pulled over. I don't do any of that work, but just as a courtesy to the community, I tend to take those calls. But for doctors, I would advise against it. So essentially, someone who suffers from one of these ailments will find a doctor, be seen with them. One has to have a pre-existing relationship with that physician, not predicated on dispensation of medical marijuana. I think the best course of action, where I'm advising the doctor or medical group, is to have an initial consult just to establish care and then come back. The second visit is for dispensation, or at least dispensation of a recommendation.
So with regard to that initial visit where you're establishing the relationship, do you feel that that initial visit can be charged to an insurance carrier as just a well visit or a checkup?
Different offices take different positions. I mean, I'm on the plaintiff side, so my my interactions with carriers is only through you guys. But can it be charged for a wellness visit? Perhaps. I mean, at least for the initial visit. But it might run into issues on successive visits.
And so once they go see a doctor, they get the proper approval. What do they do next?
So they will apply to the state. Assuming they have $50, I think that's what it currently costs to get a card. They will be approved. Surprisingly, the approval rate is, from what I've been told, pretty quickly. One gets an actual laminated card, and based on that, my understanding is they can go into a dispensary and actually get product, assuming it's available.
And with regard to that registration, is there an expiration on it?
There is. I'm a member of multiple online forums. People are complaining that they've only gotten like 3-month expirations or something that's inconsistent with what their treating physician has said. In the statute, it specifies lengths, but there are continuing abilities to renew your application.
What if I've had a criminal background that it has involved sale of drugs, possession of drugs? Is that taken into account when I apply for this medical marijuana program?
Offhand, I don't recall, but I do know that if one wants to be a caregiver, meaning, God forbid, if someone has a child who suffers from one of these conditions, that may affect your ability to get it on behalf of the child.
And I also believe that the caregiver provision also goes for perhaps if you are caring for an elderly individual and you would be the responsible party that would be obtaining the products for them. And so I believe that they also make sure that they do, there are certain criminal aspects that they look into for that also. So Steve, I have my registration card, and you said now I go to a dispensary. We went to a dispensary in Devon. Are they required to go to any specific dispensary? For example, I know my insurance tells me to go to CVS. Once I go to CVS, all my refills have to be gone through CVS.
As far as I know, any dispensary in the state is acceptable. But again, from what I've been advised, one should call ahead to see if they're stocked. I mean, we're still in the beginning of the program, so there are some issues with stockage, especially as there's going to be a high transfer to leaf, actual buds. There are going to be further issues.
And one of the things that we learned when we were at the dispensary yesterday is that when they come in, their information is accessed in a database, which just confirms the accuracy of their card. Basically, it confirms that they have gone through the proper channels and are approved to receive the product. What I found very interesting in reviewing that was it's basically a screen where they just put in the ID number, the name, and first and last name of this individual, and the screen pops up. It says, yes, they're confirmed. There is a box where a doctor could add notes. The pharmacist that was there yesterday did a couple for us. All of them had blank areas where the doctors put the notes because, as Steve said, there are supply issues. So the doctors could give recommendations, but the different dispensaries might not have that product anyway. So sometimes those recommendations are wasted. And then another thing, I asked the dispensary yesterday if there was any tracking. If I went to this one in Devon, I then left and went to another dispensary, even if I drove an hour away, do you know where they're going? And the answer was no. The answer is that the program is supposed to show that, but it does not yet show their sales. So I thought that was very interesting that technically a person could go from one facility to the next. But in speaking to the people at the dispensary, they weren't necessarily concerned about that because they felt that what they're able to give someone is a 30-day supply, and the 30-day supply is so large that if someone is taking that in one sale alone, that's already going to raise a red flag to them. So they're going to perhaps talk to this person a bit more, question them a bit more to see why it is that they're taking such a large supply all at once. But I thought that was very interesting that apparently it's coming. So Steve, we talked that first we're going to a doctor for an evaluation, then we are getting our registration. You said a $50 fee, and then we're going to the dispensary, and the doctor touched upon some of those costs. What if I am on a state assistance program and I can't afford this? Are there any funds or state help in place to help these people?
I don't know of any that have been allocated, unfortunately.
And one of the things that we touched upon, and Brock touched upon it, is when we were at the dispensary, everything that they said, all their transactions are cash transactions. Cash upon sale, there's no billing. These people get a receipt. I don't know what this receipt's going to do for them, but they do walk out a receipt, but everything was cash. And they stressed to us that there were no discounts. You know, if someone came in and they were a vet, they couldn't give them any kind of discounts whatsoever. And they, as Brock indicated, have indicated that they have not even thought about the process of going through insurance. Reading in between the lines, it sounds like they don't need to, and they're not concerned about that because they are getting so many people coming in the door. But do you believe that they can process it through insurance?
I take a very strong position that depending on the insurance, and I'm sure we'll talk about this later, that this is going to be an issue for workers' comp. If we can talk about this now, we can certainly.
Right, and we'll get to that in a minute. The way that the Medical Marijuana Act reads, under the Medical Marijuana Act, is there an obligation for insurance companies to pay?
Under the Medical Marijuana Act, I want to be super clear about this. Under the Medical Marijuana Act, no. Under any other act, possibly.
So Steve's foreshadowing. As you can tell, he's the big bad claimant's attorney that we sometimes get annoyed with, and we're like, of course he has a different viewpoint. But we'll get to that a little bit. So he's definitely foreshadowing and laying the foundation for his argument that I'm sure it's an argument in the comp court, and you guys all know that once one attorney makes the argument, a lot of other attorneys will jump on it too. So it'll be interesting to see someone who has been a forefront in that tell us their opinions, but we'll get to that in a minute. So what if I am approved in Pennsylvania? Can I go to another state and seek the product?
For medical purposes, in some states do have reciprocity. Offhand, I don't recall which states do. But in practical applications, and again, if people in the back can't hear me, just raise your hand like that, and I'll speak louder. Thank you. From a practical standpoint, what people tend to do is they just buy recreationally, which is more expensive, but it's just what we've seen happen. We've seen an influx of people actually leaving states without access to medical marijuana to states like California, to states like Colorado with more liberal medical marijuana laws. In the industry, we call them medical refugees. These are people who've had to leave their friends, families, homes, and careers just to care for their sick and loved ones.
And just something that's also important to note, which we kind of brushed over a bit, and it seems obvious, but of course to be approved in Pennsylvania, you do have to be a Pennsylvania citizen. So that's also very important to remember. And I that was assumed a bit, but I should never assume anything, I suppose. The doctor had just touched upon this with banking. One of the biggest things we heard yesterday was cash, 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 cash. That's the theme. It's a cash business. Why is it a cash business? Why are there issues with banks? And why are there especially issues with federal banks?
So I have a more nuanced opinion on this. I take the position it's not illegal for banks to deal with this. It's called the Valentine's Day memo. I mean, that's in the industry, that's how we refer to it. It came out Valentine's Day 2015 from FinCEN. And essentially what they were trying to do was to make it easier for banks to deal with this. The problem is, from a liberal reading of this memo, it seems to indicate that banks could be prosecuted for really highly attenuated situations. So what will happen is banks are notoriously very conservative. So you'll deal with agencies like PNC that they're making enough money that they don't need to deal with this. So they're looking at it that this is very difficult. So when I talk to banks, they're looking at it from it's very cost prohibitive. I represent some dispensaries in the area, and when we come to banks looking to get accounts, we're very transparent. And if we're offering them between $800,000 and $1.2 million cash deposits a month, they're looking at it like, oh my God, we need to increase our security, our manpower, to count cash that all smells like marijuana. You know, that's an issue. So that, in my experience, that has been their sticking point. I mean, banking is a highly regulated industry, dealing from everything from the lumens of a light bulb above an ATM to the APR rates of a 2008 Ford Focus. You know, they don't want to deal with this, essentially, and there's a whole bunch of issues that this causes within the industry. You know, we're talking about going to a dispensary, having an armed guard. I've had putative clients come to me and talk about security issues, and they're talking about, can we have an armed security person? And the question within the backdrop is this in contravention to the federal law of having guns and drugs? Like, can we do this? How do we secure $800,000 to $1.2 million in cash every month? And my advice is often as pragmatic as it is legal, which is the unfortunate reality of this industry. If one is going to rob you, I'm not talking someone who wakes up and like, oh, I need money, I'm going to do something. Someone who's going to knock off a dispensary, has cased the area, has made a plan from every avenue of it, and is aware that you have an armed guard. And I've told my clients, what's going to happen to your armed guard?
Shot.
Right. So do you really want to have that conversation? I mean, insurance companies will cover the loss. Up until last year, Lloyd's of London was insuring this for everything, you know, catastrophic crop failure, federal intervention, attorney's fees. That's nice. So, I mean, just hand it over. So lots of issues with cash. We could take an entire hour just on that in terms of cryptocurrencies. It's not entirely true that it's all cash. I have written advisory opinions that they can use what's called closed loop systems. The next time you go to Acme or Giant and you see all the, you know, $25 gift certificates to Applebee's, that's considered a closed loop card. You could actually, my understanding is you could actually buy one of those cards, you know, pre-charge it, you put $100 on it, you can come back. That you can do. And you can use a credit card to do that. So it's not entirely accurate that it's all cash.
And also flexible spending accounts is what have been used at dispensaries, we've heard. That's what we heard yesterday. Thought that was interesting. One of the things that is an uncertainty in Pennsylvania is that in federal law, there is no medical marijuana laws that allow for it. It's a Schedule I drug. It's illegal. So how are we today sitting here talking about a Pennsylvania law that is in place and it is actively moving forward right now?
Got it. So when I'm no longer taking on new clients in this space, but when I was, I would have any number of conversations, and this was reflected in my representation agreements, any kind of advisory letter. You know, your standard email clawback says this is privileged, you know, information. Mine essentially said, you know, this is illegal, right? So, I mean, I have to have conversations that, you know, we can't pretend what we're doing is legal. So when people would ask my legal advice, said, you know, it's a gradation. You know, how risky is this within the scope of what we're doing is federally illegal? And we can't lose sight of that in any step of the way.
And one of the things that happened was, you all may have heard of it in the news, but didn't quite know what it was referring to. There was a memo issued by Jeff Sessions that said, state marijuana policies, they're illegal. We're going to enforce them. We're going to go after them. But then what happened when they passed the budget in March? They included language that said federal funds are not going to be used to prosecute states that have these medical marijuana laws for those medical marijuana laws. So that seemed to return to a bit of a status quo where, as Steve indicated, maybe the risk has gone back to where it was before that Sessions memo was issued. But as Steve also indicated, it's illegal in the eyes of the federal government. But how illegal, that's to be seen. Do you anticipate in the future either the federal government starting to go after these states, or the opposite? Do you anticipate the federal government allowing for or implementing across the whole United States global programs that allow for medical marijuana?
In terms of expansion, I see it going, and this isn't just my opinion, it's been echoed through NORML. I'm on the NORML's legal committee, marijuana policy project, and experts in this field. See it going on a state-by-state basis, much like we saw with alcohol. A concern for Pennsylvania was with the spending bill. So there was a omnibus spending rider, and this started in 2014-15, which prohibited the federal government, as was just said, from appropriating federal funds to prosecute states with medical marijuana programs. And instead of saying any state with a medical marijuana program, it listed each state by name. You see where I'm going. And the fear, at least my fear, was when that Omnibus Act was up each year, Pennsylvania wasn't initially listed on it. So, by extension, I was thinking, it's a domino effect. I lost count of how many senators, U.S. senators, sit in districts where with legal access to medical marijuana, and the Department of Justice had last year had a $3 billion budget. If their budget is getting shrunk to prosecute this, it's someone at a top level brass saying, uh-oh, are we at the point of no return? We have to start using our money, otherwise I have to lay off my friends coming to Pennsylvania. That was certainly a concern, and thankfully, it was overblown. Pennsylvania subsequently was incorporated into the.
So I want to jump forward a little bit. Steve, you had a behind-the-scenes look of what was happening when the act was being passed in that time period. What were concerns that were expressed by employers? What concerns do you think that the act addressed, and what concerns do you think still remain outstanding?
Sure. A big concern that I saw from multiple state senators and representatives was they were concerned that more people would use drugs. Specifically, if we initiate a program for medical marijuana, more people will use medical marijuana. Perhaps the doctor can substantiate this, but I take the position that no, more people will not use it, more people will admit to using it. If we take the stigma off it, then more people are more likely to come forward. The people who were most recently advocating for this, we saw a huge swelling shift away from people in Grateful Dead fish shirts to soccer moms. The people who were most vociferously advocating for this would likely take issue with the Cheech and Chong poster. They'd say, I have a kid with ALS. I have a kid that suffers tremendously. I've never done drugs in my life. This is what's going to help them. So employers were concerned about more people using it in the workplace. The act attempted to seek a middle ground. Unfortunately, there's some major flaws. Bad news for public policy, great news for trial lawyers, both sides. In terms of, from the plaintiff's bar, the Act has an anti-discrimination provision in here. One cannot be, and we need, I think it would be beneficial to break that down, but from a 30,000-foot view, one cannot be discriminated against based solely on one's medical marijuana usage. However, there's no, within the Act, there's no explicit private right of action. So if someone calls me and says, hey, I was fired because of my medical marijuana usage, can I sue? The problem is there's no place in the Act that allows me to represent them. So if I were to do that, I would essentially have to create a public right of action, like the Schick v. Shirey case, the workers' comp retaliation. I just want to, if you'll humor me, I'm going to read one line from it that I think is going to bolster my argument. So I will be advertising to get this type of case. The court read, if a court does not recognize a cause of action for violation of this Act, under such circumstances, an employee would be placed in the untenable position of choosing between exercising his legal rights to treatment under this Act or foregoing this legal right in an effort to maintain his livelihood. Consequently, the most important public policy will be undermined where the fear of being discharged would have a deleterious effect on the exercise of statutory right. So I think the Commonwealth Court would be persuaded by that. But there's a lot of ambiguity in terms of how this would be rolled out. I'll just touch on it a little more briefly. We can come back to it to the extent it's meaningful and relevant. There are provisions within the Act specifically addressing different types of occupations, people who handle chemicals, people who work in public utilities, people who work in confined spaces or in heights, that they cannot have 10 active nanograms of THC per milliliter in their blood. I'm sure this is not news to many people in the room, that there are issues with marijuana detection in one's blood. It's public knowledge at this point that one could smoke a joint in Denver and then come back to Philadelphia 2 days later perfectly sober, but would fail a drug test. So that's a problem. So employers are placed in the untenable position of they can't discriminate hiring, firing, promotional activities based on an employee's medical marijuana usage. But what happens for a public utility worker who's a medical marijuana patient? Even if they only do it on the weekends, it's still in their system. They're still going to test positive for this. So it's going to be fun roads ahead for plaintiffs and defense bar.
So Steve kind of gave me the softball because he just set up all my questions for the rest. So Rob, let's discuss, let's say I am an employee of a company, I just a secretary, so I'm not in closed space, I'm not in charge of any kind of medical administrations or whatnot that we have to be concerned about patient safety. I go to my employer and say, listen, I've been recommended that I use medical marijuana. My doctor said, though, that the best time for me to use it would be at noon, but my shift is from 9 to 5. As an employer, do you have to accommodate that use?
The short answer is no. You don't have to accommodate the use while on the job. The issue, though, I think arises, and we may touch upon this too, that also within the Act is what is the standard of care for the position in question, which may lead down the road to I think, additional litigation of what defines the standard of care for a job that's not enumerated as falling within the 10 nanogram requirement. So although you don't have to accommodate for the job, that lady or gentleman may actually use the medical marijuana off shift at home, and then you have this issue as Steve was touching upon, that they may appear to be under the influence or have an issue when they return to work. And the issue of standard of care is not, in my opinion, clearly defined, which causes a problem from the employment defense perspective, because how do we define that? We would need to look at things like job descriptions and policies and procedures, which I think is also going to open the floodgates for yet more litigation on this issue.
I just want to jump in here and provide a different perspective. Rob is completely right. In terms of...
We should just stop you right there, right?
Yeah, sure.
Thank you for coming.
There's a big but comma coming. When looking at the four corners of Act 16, it says nothing in this act should be construed to require reasonable accommodations. What about other acts? So from the employer's bar, one of your clients discriminates against one of my clients, doesn't offer a reasonable accommodation, I'm coming after you on a different statute, not this one. Civil Rights Act of 1991, that's how I'm going to get you. So unlike Title VII, unlike ADA, original and as amended of 2008, unlike PHRA, unlike the Philadelphia multitude of ordinances, there are clear definitions that current Schedule I drug use is outside of protected reasonable accommodations. However, 1991, Civil Rights Act of 1991 has clearly delineated carve-outs when someone is seeking current usage of this, meaning it's been recommended. So that's how I'm going to get you. Careful.
So, can I ask a question?
Sure.
Now, I've got a friend who owns a company that does work with the federal government. And his concern, he actually brought this to me a month ago. He said, I have some employees that will randomly be tested at this defense site that they work at. And they're candidates for medical cannabis. And he said, now, can I actually, and he himself is saying, I think these guys need to use this because they have some back problems. I don't want them on opioids. And I didn't have an answer for him, but except that I said, from a federal standpoint, I think you're probably in pretty significant jeopardy there. So it's not a state, it's a federal issue with this guy.
Yeah, I mean, there are so many issues that come up with that, and that's really fact-specific case. Is this a federal employee? Is this a federal contractor? There are different standards when evaluating something like that. I mean, either way, you're an employer and you mess up one of my clients like that, you're getting a demand letter. Enjoy.
Question. So for the drug screen, can you tell the difference between medical and recreational?
And
So
that's
another
yeah,
question.
and that was one of my questions to the panel was, what if I'm an employer and contingent upon employment is you passing a drug test? I mean, do I now have to make an exception? And how also, as an employer, I would be very skeptical of because I have a medical marijuana card. And I mean, as an employer, can you even ask that question of, do you have a medical marijuana card? Are you taking these drugs?
Well, from my perspective,
Pretty loaded question, I apologize.
If that question is asked during the interview and for some reason that individual isn't hired, you're probably going to be getting a demand letter from Steve. I do think it goes as to timing of, is it post-hire, pre-employment, as a part of the pre-employment test for across-the-board drug testing for a new employee, or is your industry regulated? Some industries are regulated, such as healthcare or the I'm sorry,
Trains.
Yes. So they would fall within, I think, issue of having a basis to deny employment for for medical marijuana use. The rest of us, I think it's a sticky wicket, and you're not going to get a straight answer for something that you can take home across the board and say, in every situation, this is what you have to do. But the timing is really important as to when that comes up. And then when it does come up, you have a dialogue with the individual. Is there, I made some notes last night. If the employee has or the applicant tested positive, somebody, most likely the medical director that's conducting or overseeing the test, would need to confirm, like you would any other drug test that you might have at your work. So if you have somebody that tests positive for oxycodone, the process is that you confirm that that person in fact has a prescription for oxycodone to validate the test. Same process for medical marijuana. The process would be to have some proof of what the use was, and that would be through the card that is issued. There's really no, in my mind, no clear answer of what do you do in the situation. A lot of it goes to your policies, your EEO policy, your employee handbook, the job that is at issue. So it's really, I think, perhaps an industry or employer by employer review that I would conduct if I had a phone call. Try to avoid the demand letter from Steve.
So I'm sure your answer is going to be quite similar in this scenario. But now I'm thinking of a scenario where I am a drug-free employment. That's our policy across the board. And I have an employee who seems off, and I'm not sure if it is marijuana or another drug. How do I approach that, and what if that person is a medical marijuana user? Am I now then crossing boundaries that I shouldn't be getting into?
Yeah, so the answer is possibly. It depends. Many of our clients have zero tolerance policies where it is against company policy to be under the influence of any sort of drug, alcohol, or prescription or narcotic of any sort. It goes back to, I think, what your policies are internally to start. Do you have a reasonable suspicion policy that you can rely upon to assess an individual? It also looks at whether or not that individual may be endangering themselves if they are under the influence, whether it's marijuana or something else, or would they be endangering others? And again, you would look to what the industry is as well. I think when you're trying to assess, the likelihood of or appropriateness of a reasonable suspicion test. Kind of as a quick tangent, if you have post-accident testing, let alone the issue with marijuana, you have a whole issue now that you need to address through OSHA if you are implementing or have an across-the-board post-accident testing policy. So I think that there are other rules. I mean, that was an OSHA rule that was buried in record-keeping requirements for all the employers. There are other rules and regulations that I think intersect this issue like many other employment issues that would arise.
From the plaintiff's bar, I think you're asking for trouble with drug test employees. I think there are a lot of issues that will come up. I mean, just as Rob said, OSHA issues. What if they come back from FMLA and you would drug test them? You do that, you're setting yourself up for a retaliation interference claim. And there's a whole bunch of case law that came out of California that I'd love to bring here. Public policy, privacy violations. If anyone who's done any constitutional work, Pennsylvania's constitutional protections, the Fourth Amendment, is actually stronger than the United States is. So you might be setting yourself up for that. And it's also a cultural thing. So I was asked for one of the dispensaries I had represented to write a drug-free work policy. So you're an idiot. You realize 100% of your budtenders smoke pot, right? You yourself are a drug dealer. You cannot do this. So I think a lot of this is rested in antiquated notions of what it means to be operational in the 21st century. I mean, there are reasons why Google and other big silicon firms have moved to areas with liberal drug laws, because they don't want their programmers to get arrested. I mean, there are a lot of big considerations that go into this, and I think this from the litigation bar, and especially the defense bar, there's a lot of opportunity here for advisory opinions.
And I'll just interject a point.
Wait, we're running out of time, so I'm sorry, I just want to have Steve tell, because I think this is going to be probably what's most interesting to most of you sitting in this room, and then it'll tie us into the final section of the program, which will focus a little bit on workers' compensation claims, so that'll be most interesting. Steve has actually filed a claim petition. It is pending before Judge Rago here in Philadelphia, so I'm sure a judge many of you are familiar with. And I want Steve to give a brief synopsis of what he is going for in his cause of action, and his goals, and a very brief synopsis of his arguments.
Sure.
Sorry, Brock.
I filed the claim petition, claimant tripped and fell, place of employment, complete Achilles tear. Pretty wicked. About 6 months ago, we had our initial hearing in front of Judge Rago, and the poor defense lawyer sandbagged him. I apologize profusely for it. It wasn't my intent.
Like I said, big bad plaintiff's attorney that we,
When we were wrapping up, Judge Rago said, "All right, Mr. Auerbach, anything else?" Which everyone been in front of Judge Rago, the answer is no. See you in 3 months. And I said, yes. So what happened? I said, well, my office has targeted this case in conjunction with the ACLU to be a test case to compel insurance carriers to pay for medical marijuana treatment. You could hear a pin drop in hearing room C. What I've done in anticipation of this case going all the way up the chain of command, I have taken my medical depths, and I've taken a depth of Dr. Matthew Roman to substantiate a need for medical marijuana. The defense has argued that it's unreasonable at this point. I need to go through a UR basis, which I concede that I will, but I had that doctor testify that my client also has chronic neuropathic pain. So I'm expanding the injury there, so there is a basis for me to have taken that deposition and have an evidentiary basis for this. Last week, I asked the defense lawyer, just pick it up. And he seemed inclined to do it on a limited basis, and then kind of backpedaling. But we'll see what happens. I'm going to ask for an expedited brief schedule, and I'm going to let the appeal board know if it gets that far that, hey, this is an issue that's going to go all the way up. I'll probably get aliquotter. So it'll be fun.
So on that note, we're just going to take a very, very quick break, and then Jason and Adrian are going to talk about some of the comp side of things, and really for those handling claims, what you should be looking out for, and maybe if you want to pay, how you can pay.